Good morning, everybody. I'd like to welcome you to PIA Law's Practical Strategies webinar, Understanding the Catastrophic Impact of the Coming SABS Changes. We have over 300 people watching today and almost 400 registered, so I think that gives us an indication of the level of nervousness out there over these SABS changes. Before we get into the substance of the program, I want to touch on a few housekeeping items. At the bottom of your audience console, there are multiple application widgets that you can use. If you have a question during the webcast, you can click the Q&A widget at the bottom and submit your question. We'll try to answer these during the webcast, but if a fuller answer is needed or we run out of time, the questions will be answered via email. Additional materials are available. There's a resource list widget that you can look at. It's a green folder at the bottom of your screen. You can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulties, you can click the help widget. It has a question mark icon and it covers common technical issues. And lastly, an on-demand recorded version of this webcast will be available in about a day from now. So after the webcast, you can access that using your audience link. I'm Dale Orlando from McLeish Orlando. To my left is Darcy Merker from Thomson Rogers. Beside him is Dr. Ron Kaplan, who's our special guest here today, and he's here from Hamilton, Ontario. And lastly, we have Ryan Murray from Oatley Vigmund, and we'll each be taking a turn covering the substantive portions of the program. And first I'm going to start with Darcy Merker. He's going to provide us with a review of the major reductions to the statutory accident benefit system and also touch on the transition rules.
Morning, everyone. I'm going to spend less than 10 minutes talking. The first few minutes I'm going to review the major changes that come in on June 1st, 3 weeks away. After that, and that's going to be a review of probably things you already know, but a refresher given that it's 3 weeks away and we've been working under a current and older system. Then I'm going to talk about transitional issues, which may not be something that everyone's up to speed on and should be important to understand what new rules do apply to ongoing cases versus the June 1st cases, post-June 1st cases. And then I might touch upon some solutions to get around some of the problems before I pass it on to my colleagues. So to start with the quick review, as of June 1st, for accidents on or after June 1st of 2016, some 3 weeks from now, there have been some major reductions. The first one is for non-catastrophic claims. So the bread and butter, the concussion cases, the mild brain injury cases, the fracture cases. It used to be $50,000 in medical benefits plus $36,000 in attendant care benefits, so a total of $86,000. For accidents on or after June 1st, that limit goes down to $65,000 total. So it's reduced by, $21,000. There is some good news, though, that it's now Freedom 65, meaning you can use your $65,000 under either the med rehab or the attendant care in kind of any way you want, subject to the standard $3,000 per month cap. It's also been that the duration that you can access those benefits has been reduced to 5 years from what used to be 10 years for the older cases, with the exception of the children under 18 at the time of the accident have non-cat benefit rights until age 28. So that's the non-cat issues. With respect to the catastrophic limits, we have a new math, which is 1 + 1 = 1. So $1 million in med rehab benefits plus $1 million in attendant care benefits now is stuck with a combined total limit of $1 million as opposed to the predecessor of $2 million. So we have half the money to work with, and even less than that as I get to the third change. And the third change is the non-earner benefits. Non-earner benefits are available to students, children when they become of age, retirees, stay-at-home parents. And it used to be that you were eligible for life until age 65 and then at a ramped-down amount. And now eligibility is limited to 2 years with a shorter 4-week waiting period as opposed to the earlier 6-month waiting period. So the amount available has gone from hundreds of thousands of dollars over your lifetime to what's now a total maximum of $18,500 over that 2-year period after the waiting period. So the fourth key change is that they've switched the other goods provision to say that only other goods of a medical and rehabilitation nature are obligated to be paid by the insurer if the insurer agrees they're essential. So historically, a lot of occupational therapists relied on this section to get certain treatment approved, like the use of electronic devices, for example. We suggest that people no longer rely on this because it gives the insurer basically an absolute veto because they have to agree it's essential before paying it. So it gives them the ability to pay for things outside the box, but no obligation to do so. So instead, rely on the other enumerated headings for med rehab benefits. And then the last change, which we're going to be talking about at length today, and the last major change, is the revised definition of catastrophic. And I'm not going to get into detail on that, other than to say we now have the elimination of the GCS test for June 1st and on accidents, which means that there's no, at least in brain injury circumstances, immediate access to a CAT designation and what comes with it in terms of a case manager, enhanced attendant care, etc. So that's the quick recap of the major changes that are coming in. But let me now move to the transitional issues. So the first thing to understand is that the new definition of catastrophic for accidents on or after June 1st applies to everyone. It applies to old policies, it applies to optional benefit policies, it applies to everyone for all accidents June 1st and on. When it comes to the caps, the non-CAT reductions and the catastrophic reduction down to $1 million total, that has some exceptions. So a couple of those exceptions, which everyone in the audience should be aware of, are two primary ones. One is unrenewed auto policies. So auto policies are generally renewed annually, meaning that if you buy one today, May 10th, it doesn't get renewed until May 10th of 2017. And if you just bought one today, then if you're injured in an accident this summer, after June 1st obviously, you still get to access the enhanced quantums, so the $86,000 rather than the $65,000, and the $2 million total CAT benefits as opposed to the reduced limit of $1 million. So for anyone helping accident victims after June 1st, the first question you should have is, are you working under a new policy, a June 1st, 2016 policy on that was just renewed, or can you access an unrenewed policy? Because it could be $1 million swing if it's a catastrophic designation. But again, the new definition of CAT still applies even in that unrenewed situation. And the second issue is optional benefits. Now, optional benefits have not historically been popular. They've usually been purchased by 2 to 4% of the population. But come June 1st, it's quite possible that optional benefits become more popular and get up to the 5 to 10% range, so that we should all be careful to look for access to optional benefits, because you can purchase optional benefits to have your case treated with higher benefit limits or treated as catastrophic regardless of having the catastrophic designation. So consider the unrenewed aspects and optional benefits for accidents that happen in the first year following June 1st, 2016, so up to the end of May of 2017. So I think I've touched upon the major changes and some of the transitional issues. We're going to be inviting questions about the changes at the end of the presentation, and I'll pass it over to Dale.
Well, I guess, Darcy, one question for you is there any argument that the changes that are effective on June the 1st will apply to accidents before June the 1st? Is that an issue or a concern?
Okay. So for ongoing cases, the catastrophic definition expressly applies to all accidents June 1st on. Now, an innovative lawyer could argue that, hold on, if you paid a premium for a policy before that and you want to rely on the GCS test, you should be allowed to do so. But because it was expressly written, it's unlikely that it's going to succeed, and you're going to be stuck with the new June 1st definition regardless of whether you had a policy that was unrenewed that predated that.
Okay. What about Form 1s? Are they still going to be required?
Okay, so Form 1s, because of this Freedom 65, it may be that lawyers do not want to get into the incurred battle being proof that family members who are providing care have suffered an economic loss and then proving the extent of that economic loss, or alternatively outsourcing it to professional organizations to provide the attendant care. So I think commonly all lawyers are going to want the original Form 1 done, but after that, once you have the Form 1 amount in, if you're not accessing it in full, it's unlikely that we're going to want it revisited regularly to eat out of the $65,000 because all that $65,000 could be used for medical benefits. And the one issue I'll add is that when it comes to the catastrophic assessments, and Dr. Kaplan's going to be talking about that, but the cost of those assessments, one, they can be funded by reputable personal injury lawyers who are advancing tort claims and otherwise. But there also is a way, in accordance with jurisprudence, to have the CAT assessment costs paid by the insurer out of a fund other than the med rehab and the attendant care. So out of a separate fund of money, an unlimited separate set of fund of money. So when it comes to CAT assessment costs, all health practitioners should be aware that it should not, in accordance with this decision called the Henderson decision, come out of the med rehab funds. It should come out of a separate pot, and they should make sure that the lawyer double checks that the insurer is not wrongly taking it out of their $65,000 or $1 million available.
All right. What about mileage charges?
So mileage charges, as we all know, is subject to a fiscal bulletin, which essentially says that they don't want insurers to have to pay it. And in the new world with reduced limits, everyone's going to have to cut corners. It's going to become even more unlikely that health practitioners are going to be able to charge or get approval for mileage-related costs, unfortunately. And those we'll have to find solutions to get around that. It may be on the basis of protected accounts, where clients give instructions to their lawyers to pay providers at the end of the conclusion of a case, and there may be some other ways around it.
Well, thank you very much for those comments. Darcy hit on it, and it really is important to highlight to everyone, and I think we all have a role to play here, about optional benefits. They've been available for 15 years. Very few people buy them, and I think more and more it's going to become important. And likewise, not only purchasing optional first-party benefits or no-fault benefits, but it's a very small premium increase to go from $1 million in third-party liability coverage to $2 million, like literally under $100 a year typically. And that provides a huge benefit to people when they are injured. It's not their fault. The person in the lawsuit has $1 million in insurance and you have two, well, your policy will respond for that second $1 million. And with the reductions that we're seeing on the no-fault side, there will be a corresponding increase in the value of these lawsuits. So that's an important thing for all of us to consider, not only when we're purchasing for ourselves, but also to educate our clients about that. I want to transition now to my good friend Ryan Murray. As most of us know, we had almost like an April Fool's Day joke when on April the 1st the LAT was introduced and FISCO is out. There's going to be a lot of changes, and I'm going to pass it over to Ryan now to just give us an overview of those changes.
Well, thanks very much, Dale. Well, people in the audience who deal with insurance claims on a regular basis will probably have already heard of these changes, but those who haven't, I just want to give you a brief overview of how denials of accident benefits claims are going to, how they're going to look going forward and how they've actually already started to look as of April the 1st. The first thing that's gone is the requirement to mediate denials at the Financial Services Commission. Our viewers probably remember that was the initial step that was required for any denial before you could get into a dispute with the insurer, either by arbitration or by lawsuit. So now if a denial comes in, you have 2 years from the date of that denial to make a decision about whether or not you want to go to the License Appeals Tribunal, which is a new government, well, it's an existing government tribunal that the accident benefits piece has been moved over into. So you no longer have the ability to either commence an arbitration at the Financial Services Commission about a denied benefit, and you no longer have the ability to sue in the Superior Court about denied benefits. So everything now is going to be at this new License Appeal Tribunal, and it's only been up and running for about 5 weeks now. So I think it remains to be seen how that's going to work, but I can certainly provide an overview of how the new process is going to work.
So what is it expected to look like?
Well, one of the things that's supposed to change, and obviously there's nothing in the legislation that requires these timelines, but the government has come out and said that it's going to be a lot faster than the old lawsuit or FSCO dispute resolution process. Under the new system, the expectation is that the LAT is going to deal with 90% of all denials within 6 months of the time that the dispute resolution process starts. So that's a major change. And now another thing that's changed is that insured people need to pay to access the process. Previously, that was not the case if one went through the arbitration process. So you need to pay $100 for each opportunity to use this license and appeal tribunal. So lawyers and insured people are going to have to choose wisely in terms of when are they going to make an application to the license appeals tribunal, because you would hate to be in a situation where there's a dozen denials of various treatment plans and you're spending $1,200 to get those before the license appeal tribunal. So once this application is filed with the LAT, the insurer has 10 days to respond with a form of their own. After that, there's a 45-day window during which time there's supposed to be a telephone case conference that takes place with an adjudicator. This is sort of a settlement conference, and from what I understand, the adjudicator is supposed to work with both sides to try to get the issue resolved without going to a formal hearing. And if unfortunately that's not possible, the next step will be this adjudicator, who will not be the adjudicator at the hearing, to choose how is the hearing going to proceed. There's 3 types of hearings under this new system. The first is a written one, which I presume will be for small treatment plans. The second is an electronic form where you've got a combination of telephone, video conference, or in-person or internet witnesses. And the third is a full in-person hearing where you've got a formal arbitration-like setting like you used to see at FSCO. There's nothing in the rules of practice that sets out which of these 3 options is going to be chosen for a particular case, but I can only presume that the highest level with in-person witnesses will be reserved for things like catastrophic impairment and post-104 weeks income replacement benefit claims. So it's a brave new world. It remains to be seen how it's going to be interpreted, but we're all anxious to see how this tribunal process will work and whether it will really be as quick as has been promised to us.
So Ryan, now you're at a stage where you've had a dispute. One of those 3 routes has been chosen for you, and you don't like the outcome. What do you do?
Well, there's 2 options. The first is you can make an internal reconsideration request to the License Appeal Tribunal. However, they will only act if the tribunal acted outside of its jurisdiction or made a significant error of law. So that's a pretty narrow bandwidth to operate within. The other possibility for people who don't like the decision is to ask for something called judicial review, where you go to the divisional court and you have a judge of the Superior Court of Justice hear the matter, but they're only supposed to intervene on questions of law. So they're not supposed to sort of rehear the entire process and make new determinations about facts. So it's a limited right of appeal, but it does exist, and of course we'll be using it in cases where we think the tribunal gets it wrong.
Right, but it is a tight appeal route. It's not. It won't be a reconsideration of the case from the start, essentially.
That's right. The only thing I can say is that historically I've found that whatever the terms of reference are for judicial review, if the judge doesn't like the initial decision, they will find a way to get it into being a decision of law or a question of law, because they will want to substitute their decision for the decision of the adjudicator. So hopefully, although on paper it looks very narrow, we'll see that expand over time. It certainly was my experience with FSCO arbitration appeals for judicial review, and hopefully that will continue.
Now, Ryan, I know it's still early days, and there's positives and negatives, but overall, do you think this is better for our clients or worse for our clients?
Well, in general, I would say it's probably worse. The one thing that might be a positive is the speed. Right now, as everyone watching probably knows, we often have disputes about treatment plans, about major issues in the claim, and they end up going to FISCO, or they end up going into a lawsuit where they just sort of sit for a year or 2 years, and ultimately the case settles. Now, if there are things that our clients urgently need that are reasonable and necessary, this process is supposed to provide a service where we can file documents, we can have a written hearing, and hopefully in less than 6 months we have a decision that in fact these things are reasonable and are necessary, and we can implement the treatment that's recommended by the people watching this webinar. So that's one thing, if it does work in the way that it's supposed to, that might be beneficial for healthcare people. I think what remains to be seen is whether these adjudicators are truly going to be neutral and fair, and the system will be efficient, because many of these people are brand new to the accident benefits world. They don't have any sort of tenure, from what I understand. They can be replaced at the government's mercy, and so if they're making all kinds of decisions that don't favor insured people, the risk is that they're not there next week or next month. So I'm waiting to see how this plays out. My hope is that over time, adjudicators are human beings like any of us, and they're going to see the dire straits that many of our clients are in. They're going to see the unreasonable positions that insurance companies, not all of them, but many of them, take in these things, and hopefully decide on the basis that the insured person needs these services or needs these benefits in order to reach their maximum medical recovery.
Well, thank you for that, Ryan. Next, we're going to turn to an issue that's near and dear to the hearts of all of the PIA lawyers because of the nature of our practices, and we do tend to act for those with the most serious injuries. It's the definition of catastrophic, and the government seemed to create a solution to a problem that didn't exist, because I don't believe that there was overwhelming statistics that showed there was this deluge of people being deemed catastrophic, or that the catastrophic claims were in any meaningful way the bulk of the expense in the auto realm. It's actually quite a small percentage when you look at it statistically, but in their wisdom, the government has tightened the definition of catastrophic, and that's the area of Dr. Kaplan's expertise, and he's going to explain to us some of these changes. Go ahead, Dr. Kaplan.
So let me thank you for inviting me to join you today, and I hope everyone's having a great morning. We're inside, and maybe you're outside, sitting on the grass with your laptop in front of you, enjoying the sunshine. At least I'll imagine that. I have a paper which focuses on brain injury, but also covers all the catastrophic SABS changes, and I think that's provided in your material.
Yes. I believe that's in the resource list.
Right. And it addresses as many issues as we could think of, but that paper has been rewritten many times as our understanding develops, and starting June 1st, as cases come forward, we'll have a further in-depth understanding of how these definitions work. So the first question I was asked to address was regarding the mental impairment definition, which is SABS, catastrophic SABS number 8. And the question I was asked to address is that the government decided to preserve the use of the AMA Guide's 4th edition for evaluating mental impairment. And the question I'm going to answer is, when do we use the 4th edition of the AMA Guides for mental impairment, and when do we not? So the 4th edition of the AMA Guides, written in 1993, is the one we have been using since 1996. And we're going to continue to use it for almost all the catastrophic impairment assessments that require an impairment rating, qualitative or quantitative. The 4th edition has the most robust mental health chapter with the most detail regarding assessment method. And health professionals use the 4th edition mental impairment chapter for evaluating any type of mental disorder and a patient who has multiple mental disorders. No mental disorders are excluded from the mental impairment definition because no mental disorder diagnoses are excluded from that chapter, the fourth edition says to use the DSM or ICD diagnosis systems, and those include all mental disorders. So we will be looking at patients with depression, anxiety, traumatic psychological disorders, as well as those who are coping with the effects of chronic pain, and patients with brain injuries also have mental disorders, which will be covered in the mental impairment definition. So we use Guides Fourth for the assessment methodology and for assessing all mental disorders. The only time we don't use it is when we're combining brain, body, and mental impairments, and then we turn to Guide 6, and I'll be saying more about this.
Right. When the file comes to you, of course, there's a history and there's a clinical team that's typically been on the case for some period of time. What can the, and that's the bulk of this audience, what can the treating team members do to assist the CAT team leader in terms of understanding the range of impairments in the 4 domains?
Yeah, this is a very important question because one of the things we do in our assessment center is we spend a lot of time screening patients and screening files to determine if a person likely has a catastrophic impairment. So the first thing I want to mention is that we want the clinical team members to be diagnosing the mental disorders resulting from the accident. This is done by physicians and psychologists. The other thing that the team members have to do is to describe the impairments and functional changes which are part of the disorder. Each mental disorder has a particular course and a particular profile, and so we need real experts in these disorders to be describing the functional changes and the symptoms associated with those disorders. Now we have a variety of other health professionals who work with patients with mental disorders, and they play a critical role in giving us important data also. Occupational therapists, speech pathologists, social workers, nurses should assess and describe the functional changes in the patient in the 4 domains in the mental impairment chapter. So they'll be looking at activities of daily living, social function, concentration, persistence, and pace or task completion, and adaptation to work-like settings or deterioration in the face of ordinary stressors or challenges. So what's really helpful to me as a catastrophic impairment assessor is that the health professional describe what they observe in detail and comment on the impact of rehabilitation efforts, the impact of treatment, and whether the patient has responded and recovered. So in terms of screening a file for catastrophic impairment, the clinical team members are critical for the catastrophic impairment assessor.
Right, perfect. In a post-June 1 era, with a client who has both a brain injury and behavioral impairments, where do you look to do the evaluation?
This is actually a complex question, and it's challenging to come up with a precise answer, even though I should be able to do so. It turns out that of the 8 catastrophic criteria, 1 is for children, and that leaves us 7 criteria. Of those 7 criteria, 4 can be used for assessing brain-injured persons. So I'll try to make that clear how that works. The first is SABS number 4, the Glasgow Outcomes Scale Extended. This is a slightly different version of the Glasgow Outcomes Scale available to us in the current definition. So here's what the assessor does. You diagnose a traumatic brain injury, and you review the evidence for intracranial pathology by looking at medically recognized brain diagnostic technologies. We don't quite know what will be the medically recognized brain diagnostic technologies, but the legislation says we should look for those. So we have the diagnosis, we have the technology which shows intracranial pathology, and the last thing we have to do is evaluate the severity of dysfunction of the patient. Do they have a vegetative level of disability, severe, or what's called lower moderate disability? You're going to be hearing a lot more about higher and lower severe, higher, and lower moderate. What I want to say to you today is the most important distinction is between lower moderate and upper moderate at 1 year after an accident. The patient with lower moderate disability may be able to function only in a sheltered, non-competitive work environment, and they may have difficulties functioning in the community, not be able to function outside the home, and may have very significant social deficits. Those patients who can function only in a non-competitive work environment may be determined to have a catastrophic impairment. So lower moderate is the test that will be most relevant under the GOSE. Now it turns out that, as I mentioned, there's 3 other ways of assessing a person with brain impairment who might have a catastrophic impairment. At 2 years after an accident, the assessors diagnose and rate all impairments using the physical chapters of the guides. So I've mentioned that the 4th edition has a mental impairment chapter. It also has various physical chapters for bodily impairments, and we're going to be rating all of those at 2 years. The physical chapters include Chapter 4, which is a chapter regarding brain injury, brain disease, and brain disorder. So you assess the physical body impairments, and you also assess all the changes from a brain injury, the somatic, the cognitive, and behavioral. Because Chapter 4, the brain chapter, is also one of the physical chapters. So that's how we assess physical impairments. Now, there's also SABS 7. SABS 7 is a new criterion put into the legislation to look at combining impairments across mental, psychological, and body systems. So you rate all impairments, and you distinguish and then combine brain-based behavioral changes and changes produced by other mental disorders. So let me just emphasize this. We have to distinguish the behavior which results from a brain injury from the changes which result from a coexisting mental disorder such as depression and anxiety. And then we rate them using different editions of the guides. That's actually a very strange and complicated step. The key message, though, is we have to distinguish what the brain does and what the mental disorder does in terms of behavioral change. Now, the final definition where you can look at brain injury is the mental impairment definition, which we talked about first. We talked about the AMA Guides, 4th edition, Chapter 14, the mental impairment chapter. And in that chapter, you rate all disorders, including those resulting from brain injury. So it turns out that although these definitions are each individual and separate, there are 4 separate definitions where a brain injury can be considered. And therefore, starting from the day of the accident, when you're thinking about the brain injury, you have to think about using the Glasgow Outcome Scale at 1 month, 6 months, and 1 year. And then you have to think about using all the other definitions at 2 years after an accident.
All right. Our audience today is made up of speech therapists, psychologists, social workers, just to name a few, all of whom have an obligation under our system to produce records and reports. So when you're looking at Chapter 14, the activities of daily living sphere, what is it that you'd like to see in the records and reports to assist you in your assessment?
Some of the comments I'm going to make, I've already made. I'm just going to give you some more detailed answers. So when I'm looking at a file and I'm looking to determine if a person's level of function meets a catastrophic threshold, I'm really looking for detailed examples in the file, not just the conclusion, not just the rating that any of us might give, but I want the examples about how the person goes about completing their activities of daily living and the difficulties they have. So I'm presuming we have a diagnosis in the file of the mental disorder, and what I would like is the physicians and psychologists who make those diagnoses to describe the function they see and to give a GAF level, which gives you sort of a summary concept of how severely the person is impaired. The health professional has to reflect on the multiple reasons there's limitations in activities of daily living. And the health professional has to think about not just the physical injuries, the pain, fatigue, and deconditioning, but the mental changes. So for example, I would like to see in the file examples of how a patient deals with fear of re-injury, or fear of greater pain by doing things that would cause that pain. There's patients who are afraid of mobilizing because they may be stuck and not be able to come back to their home, for example. I want to know about a patient who has low motivation due to brain injury or depression, patients who feel inadequate about performance and give up. We're looking at issues such as social embarrassment about going out of the home, as well as people who are uncomfortable having others visit them at home. So we're looking at all the psychological reasons for dependency for activities of daily living. We're also looking at things like difficulties with transportation and how emotion affects pain and behavior. So the key message is don't just look at the physical limitations, because most of our patients do have physical limitations and pain. Think about how their mental disorders, which you observe in them, is causing them to limit their activities.
Right. You touched on social functioning briefly, but can you elaborate on that point? What would you like to see in the social functioning realm from these same health professionals?
One of the mistakes that's made is assuming because a patient can speak to me for an hour, 2 or 3 or 4, that their social functioning is normal. But that's not a normal situation, and it's structured and protected and safe. So we have to look beyond the clinical interview and look at function in the real world. So I'm looking for data about how the person functions in their family, in their community. I want to know about their shopping and their travel. I want to know about what happens in their personal, intimate relationships. I want to know how they function in sheltered environments, protected and safe environments, and how they cope when they're outside of those safe environments in the community. So the key thing when examining patients in these different social realms is to look at how they relate to others, how they regulate their emotions, and whether they're avoidant of social situations. So once again, detailed practical information about social functioning in the family and community.
I have the same question, but as it relates to the sphere of concentration, persistence, and pace.
Yeah. So the AMA Guides has a section called Concentration, Persistence, and Pace. It's also called Task Completion. So what we're looking for here is how the mental impairments that the patient has due to depression, anxiety, or brain injury are affecting them. We're looking at things such as mental fatigue, mental stamina, sustained concentration. But what we're really looking at, can a person finish a task they've started? For example, I've been working on my taxes for weeks and weeks and weeks. As a dual citizen, I don't have to get them done till June, so I've been putting them off. It's also detailed. So many of us have difficulty completing tasks. Our patients have impairments so that they don't complete tasks either, and they have difficulty completing even simpler tasks than we have difficulty completing. So what we're looking for is whether a person can initiate a task, can do all the steps, and can complete it without supervision and direction.
You mentioned that when we get into combining mental and behavioral with physical, we're no longer using the 4th edition of the guides. We're looking at 6th edition. I think it's chapter 14.6. What do we need to do to familiarize ourselves with that rating system?
So we're dealing with something very complex here. We are rating the brain in the 4th edition, chapter 4. But the legislature, the government decided that if we're going to rate the brain and we're going to rate the mind, we need to use a different rating method. The fourth edition didn't provide quantitative ratings for mental impairments. Therefore, assessors, all of us over the years, have been using different rating systems that we found within the guides and outside the guides to rate mental impairments. The government decided that the rating of behavior from a brain injury should come within the fourth edition, but they needed a new method for quantifying mental disorder impairments. So they looked around and they found the sixth edition of the guides, a totally different book, 20 years newer, based on a different framework. Most important thing to realize is that the new sixth edition cut the ratings for mental impairment. The sixth edition gives the same impairment rating for those with mental disorders as the previous edition gave to those with mild disorders. So a severe disorder in the fourth edition gets only a mild rating in the sixth edition. So this is a drastic cut, and what that means is there's almost no patients who will combine mental impairments, brain impairments, and bodily impairments to achieve the 55% threshold. What I say in my paper, and what I want to say to the audience today, is the patient you'd be interested in checking out in this way has about a 47% impairment of body and brain, and that patient, there may be some benefit of looking at the sixth edition and determining if they get 15% for a severe impairment to combine. But otherwise, we have taken the position that we actually can't find any examples of patients who don't have a 55% impairment due to body and brain, who don't also have 3 domains of marked impairment, who meet the combining criteria. So I know a lot of people are worried about the cost of the additional assessment of the sixth edition. I don't think it's going to be needed very often, and I also don't believe it's going to be very expensive, because all the sixth edition does is require that you do your full psychological method, your full assessment of the patient, which you've already done, come up with a GAF rating, and do 2 short psychiatric tests of function and symptoms, and come up with a rating. So when you do have to do the Guide 6 method, it'll be fairly short and inexpensive, but I don't believe it'll be necessary, because you'll already know how severe the patient's mental disorder is, how severe their physical impairments are, and you will know very quickly if you need it or not.
Sounds like it's not the days of combining getting people to 55% are over.
Yes, I believe we've gone from finding that about 4% of people make it on combining alone. It'll be close to 0%.
All right. Under deterioration or decompensation in the work-like setting, what would you like to see in that regard?
If you look at the 4 domains or 4 spheres, the domain of adaptation or decompensation is the one where our patients are more likely to currently have a catastrophic impairment when we're looking at one domain being a marked impairment. I think the audience should know that the government has restricted and tightened that definition. So now a patient must have 3 domains of marked impairment or 1 of extreme, and this is going to be much less frequent. The domain which will still be more likely to be marked will be the domain of adaptation. And in that area, what we're looking for is how the person functions in work or work-like settings. So if the person is in a sheltered workshop, we want to know how they deal with other people. We want to look at mentally, do they have the mental stamina and quickness to do work-like tasks. Most often what we're looking at when we're considering catastrophic impairment is patients who've made several attempts to go back to work and have failed, or patients who are being supported and maybe just a few hours a week and they're still working. We're usually not looking at patients who are working full-time or even consistent part-time. So it's really the quality of their adaptation to a work-like setting and their failures in work settings we're looking at. The other thing, though, is that many of our patients are not working and have not worked. So what we're looking at is how they cope with ordinary day-to-day challenges. And the two things to focus on is, does a person deteriorate emotionally when the challenges are increased, or do they withdraw and stop functioning? So we have to distinguish the patient with an emotional disorder and a patient with a brain injury who simply may withdraw and stop functioning. So what we're looking for in assessing deterioration is failure at work attempts, but also failure at attempts to get them to increase their participation in the community and leisure activities and the family.
All right. This is a question, I guess, just in general, but I'll aim it at you first, Dr. Kaplan. You talked about people that don't work, and obviously there are children that are injured in auto accidents that haven't entered into the workforce yet. And I think the message overall is that this is a significant tightening of the definition of catastrophic, but what are your views on the definition and the changes in the definition as it applies to children?
Yes. As many of the audience may know, when the first definition, the current definition, was created in 1995 and became law in 1996, there was no definition for children of different ages. And various attempts to come up with definitions for all the different ages of children really failed, because you'd have to deal with every developmental stage. And so a number of years ago, the government decided to put in the phrase, you assess the child according to the SABS, but consider the developmental implications of the impairment if you can't use one of the current SABS definitions. So the government has said that for bodily injuries and for mental disorders, you still continue to use that definition. You assess the child as best as you can using one of the adult definitions or otherwise, and then you look at the developmental implications of the bodily injuries and the mental injuries. The trouble we all have is we've been looking at the developmental implications of the 1996 SABS. I don't think any of us have put our minds to the developmental implications of 3 domains of marked impairment. In other words, for mental disorders, is there a more severe test for children than we had before? What the legislature did do that was helpful, it came up with a definition for brain-injured children. And for brain-injured children, we have 5 sub-definitions. 3 of them are functional, looking at the function of the child, but 2 of them have to do with whether they were hospitalized in one type of setting or another, whether they were hospitalized in a general pediatric center and also had evidence of intracranial damage, or whether they were hospitalized in a pediatric rehab center. So these are the automatic criteria for children. So I believe that most children with significant brain injuries will have an automatic determination because they will have been hospitalized or accepted for admission to a hospital, and probably will have some evidence of intracranial damage, or they will be admitted to a pediatric rehab unit. For those children who don't meet the automatic definition, we have 3 functional definitions using a test called the Cauchy, and one just being a general description of degree of independence or dependence on family and teachers. So I think we have an increased opportunity for early identification of brain-injured children.
Darcy, do you want to add to that?
I think, without question, the kid-cat definition is much improved and will lead to children being able to access the catastrophic impairment designation quickly and efficiently, much like the old GCS system for adults. So that is one favorable change in the legislation for children. And then when it came to the 2-year mark, you mentioned the 2-year waiting period a few times, and there are ways to get around that in certain circumstances.
Yes. Just as currently, a person who doesn't have to wait for 2 years if their condition is greater than the catastrophic threshold and not likely to improve. So At 3 months, a physician can say the patient is catastrophic and not likely to improve if it's a bodily impairment. At the date of the accident or any time after that, if they have a mental disorder and it's not likely to improve, a physician can state that, and then they can be assessed and make a catastrophic application as early as 3 months or even the day of the accident under the bodily or mental definitions. The problem with these early applications is that even though some of the time we're pretty sure the patient's not going to be improving, most of the time we don't have that confidence and we're not comfortable making that determination. And because people change over time, they may be assessed by an insurer examiner who's also will disagree that they're going to be stable and thinks they may change. And so it's very difficult to do these early applications with confidence.
Right. Ryan, do you have any positive takeaways that, this has been a sort of a overall pessimistic talk, but do you see any improvements?
From my perspective, I think that the lower moderate disability test for adults with brain injury, which is available at 1 year, may be the way that many of our clients are able to apply for catastrophic impairment. You still need the positive imaging that Dr. Kaplan talked about, but from my understanding, it's an inability to work except in a sheltered way, and a need for assistance when you're out in the community. And if you meet those two criteria, plus you have positive imaging, then you can put in an application. And I was wondering if Dr. Kaplan could give us his thoughts about that particular test and whether he thinks many people might be captured by it.
Yeah, I think there's nobody who's going to be applying in vegetative
Right.
at 1 month. There are a number of patients, and we have certainly under the present GOS system assessed a lot of individuals at 6 months. There's practical issues getting the data collected, getting the applications in. There will be certainly some people with brain injuries who desperately need to have the determination at 6 months. And I think some of those will actually be applying under the AMA guides because they're so badly brain damaged, and they can apply, at 3 months. Or if it's a brain injury and it's a mental disorder, they can apply on day 1.
Right.
So I think for the most serious patients, one has to look at the mental disorder definition, the bodily and brain definition, and the combining definition starting immediately after the accident, and also look at applying for a severe disability at 6 months. So from day 1 of the accident, begin thinking about, is the patient likely to meet any of those 3 criteria and how soon? The practical difficulty is getting all those applications in and moving forward. The insurer then has to respond. So that's why I think a lot of applications aren't going to happen until 1 year when the patient is lower moderate.
Right. And as a walk-away message to the health practitioners who are watching, I think what may be good advice is at the 1 year anniversary of a post-June 1st, 2016 accident, if the person still needs supervision in terms of the Form 1 assessments or what an OT would assess if they were asked to, then they should tweak to calling the lawyer who should have a handle on all this in the first place to consider the issue of a catastrophic designation on that basis.
I think that's a very important observation. One of the things I didn't mention is when I'm screening a file, I look for things like what GAF have the various psychiatrists and psychologists given. But I also look at the attendant care, and I look at the dollar amount, but I also look at the content of the attendant care. And if OTs are consistently giving very high numbers to the attendant care, that's a sure indication that the person may have a catastrophic impairment. So we have to look at all that and follow carefully. So I think for the severely brain injured, it really means sitting down within days or weeks of the accident and looking at what the options are. We're talking about patients who need a full team when they're discharged home. Can't be left alone, need intensive treatment. So within a few weeks, people have to really think about which tests might apply because we no longer have the Glasgow Coma Scale. I want to emphasize that if you're in coma for 29 days and you wake up on day 30, you're not catastrophic.
Right. Vegetative for 3 weeks doesn't get you there.
You're not catastrophic. So it really means that the lawyers and the team have to start talking within a few days of the accident.
Yeah, the work starts on day one, really.
Right, and maybe we can shift to some practical issues of, without the GCS tests, when we get the calls, and the PIA gets the calls from the patients are at the trauma hospitals, what would have otherwise been a clear catastrophic situation, where normally we'd quickly, after getting retained, have a case manager involved, have a Form 1 out, equipment done without concerns for limits, and the rest of it. How are we now going to respond to those issues in terms of getting that team in place? Does anyone have any insight on suggestions on how to deal with some of those hurdles?
Well, I think it's going to be a reevaluation by all the rehab people about how many times they can touch the life of these clients early on. I mean, it's unfortunate, but in terms of discharge planning and in terms of involvement, until the issue of catastrophic is resolved, there will have to be limits in terms of certainly things like case conferences and team meetings, and there may need to be more frequent telephone check-ins and less frequent in-home meetings with the clients, because we're going to have to stretch these dollars further. The only other suggestions I have are attempts to involve public-funded services to the extent that they're available. And then the other issue is protected accounts. I mean, if there's a good tort claim here, a reasonable, an experienced personal injury lawyer is going to work with the treatment people to ensure that the services are there and that there's payment provided later on when the tort claim settles. There's also obviously a possibility of advance payment. So I was wondering, Darcy, if you had thoughts about that.
Sure. So, and I think those are a lot of the right points. Is that we're going to be a bit handcuffed to get the case managers out right away. And I suspect that insurers, once they get their head around the new legislation, are going to deny treatment plans in relation to what's clearly case management services unless it's a very obvious case where they're going to meet the new definition of CAT. So we're going to need the OTs to wear more of the case management
Two hats,
Two hats, at least at the beginning, and to be cost conscious at the same time, knowing that we're working with this $65,000 cap until we get the catastrophic designation, which may be delayed or may have to fall under a different delayed heading. In terms of the tort case, whenever there's a tort case and a pedestrian who's not at fault is hit, or a passenger, we have a lot of flexibility as advocates in terms of coming up with innovative solutions to help the patient access treatment and care. One is protected accounts. Another one is asking the responsible insurance company who caused the accident or is going to be found responsible to make an advance payment. And what we do, and the PIA lawyers generally do, is in those cases we get those advance payment requests out right away and highlight the severity of the problems and what will be the reduced limits and the delayed CAT designation, and say, we are trying to mitigate, we're trying to help this person get back on with life. Please facilitate that. And if they don't, it'll come back to haunt them, and that's why we do send the letters. So advance payment requests and rushed, expedited tort cases are going to become the norm.
Yeah, and I mean, protected accounts are an interesting thing because for the health professionals, the health practitioners that are working, if there isn't a tort case, and people say, well, we'll work on a protected account basis, you've got to be careful because the new CAT definitions are tight, and we can't say with a lot of confidence right now, yeah, we'll get this person CAT. Under the current regime, the lawyers who've been doing this for 20 years have a pretty good sense of what's going to be CAT and what's not. I think there's caution that should be had going forward if there isn't a tort case. If there's a tort case, it's easy. You can say, well, look, we'll protect your account if we don't ultimately have our client deemed catastrophic. We still have the tort case. We can make sure you get paid that way. I hear a lot of stories from health practitioners who say, well, I've worked on a protected account basis with this law firm or this law firm, and ultimately they're not getting paid at the end of the day. So obviously you're going to want to pick and choose which lawyers you work on a protected account basis. You have to have faith and trust in that lawyer. But you also have to ask some questions about, the viability of am I going to get paid on this protected account? That's going to be an important thing. And you're going to have to trust the lawyer that you're working with, that they have a good handle on whether or not there will be success in getting you paid down the road.
And I think timeliness, as a general principle, more important than ever. I mean, we see so many cases that start off with less than perfect representation, and we don't get the cases until 2 years later when somebody advises them to get a second opinion on the value of their case and the way it's being handled. Now, without the automatic GCS designation, that's more and more important. Historically, even with less than perfect representation, one could get the catastrophic designation and then therefore access some attendant care, some equipment. Without the automatic designation, more and more people will fall through the cracks. So it really highlights the importance of getting quality representation right from the beginning to get things on the right track.
Well, and as Darcy said, there is this fine balance of wanting to paper the file and start working towards the catastrophic designation on day one in your brain injury cases, because your best shot is a year out, but at the same time, there's limited funds, so you've got to try to budget a little bit. So it is going to be a bit of a balancing act. It's that point in the presentation where we're turning it over to questions from the audience, unless anybody has any last thoughts before we do that.
Let me just comment further about the complexity with the brain injured person. And it really is an issue of our ability as health professionals to give a prognosis and to advise the family and the lawyer as to what to expect. And I guess that we all have cases where we have a very high level of confidence, but then there's the majority of cases where the outcome is unpredictable. What seems to be only a moderate injury is a profound impairment at the end of the day. What seems to be a profound damage to the brain is a person who ultimately is able to achieve some level of independence. So that's the difficulty we face trying to make prognoses within a few weeks of an accident. A few months out, of course, things become clearer, and at that point, the first catastrophic impairment applications can be developed. What I see happening, though, is that a number of the brain injured persons are going to have to apply multiple times under different criteria to the insurer. And, the present system allows for multiple OCF-19s for different criteria. But now there's going to be an even greater need, and that's a costly process in terms of putting together the documentation to support those repeated applications. And also the ability of the insurer to respond in a timely manner to those multiple applications. Can an insurer get an IE done in a few weeks? Can that dispute go to the LAT and get resolved? Because we actually, I think it's in some patients' interest to have multiple OCF-19s go in under the different criteria as their progress is being made towards that incomplete recovery.
All right. We've got a bunch of questions here, and more keep rolling in, so why don't we try to tackle some of these. First one's interesting, and I hadn't thought about it, but this viewer suggests that if interpretation services are being charged out of the med rehab budget, it's prejudicial and unfair to those who don't speak English. Does anybody have any thoughts on that as to whether they will come out of the combined med rehab attendant care budget, and is there a way around that? Darcy?
I think we all agree it's wrong to charge over the med rehab. Unfortunately, that's often what happens. I've taken the position when they send IE notices that they're going to have to pay for translation costs, and it should come out of a separate budget, and they should use that same kind of budget to pay for translation services.
Right.
But it's a big spend for every assessment, for every session, to have an interpreter there, and it does pose problems, and it will potentially rightly be taken out of the med rehab funds, unfortunately.
This is not an issue about interpretation, but something that many healthcare people and a lot of lawyers don't know is that HST is not supposed to be included in the limits under the accident benefits, and so we're having many clients who currently are exhausting their $50,000, and 13% of that is HST, and we can go to the adjuster and actually get a little bit more. Now it'll be even greater under the $65,000. So that's an area where a lot of insurers aren't even looking at it, and a lot of lawyers aren't looking at it. But it's extra money in the system that might be able to fund things like interpretation costs.
Thanks. Somebody wanted some further information on the Henderson decision. I don't know if either of you have anything up on your websites about it. I don't think we do, but
I think on my profile there's an article I wrote about it. But essentially, it stands for the proposition that the CAT assessment costs, so that when Dr. Kaplan submits a treatment and assessment plan that's approved to do a full-blown CAT assessment, and the cost could easily be in the $10,000 or $20,000 neighborhood, that is supposed to come out of a separate fund, not the Med Rehab Fund. And the Henderson decision says that, and it's been upheld, or it's been other cases that followed it. So if an insurer is taking the CAT assessment costs out of the Med Rehab Fund, a letter should go out from their lawyer saying, take that out, it's wrong to do that, see the Henderson versus Wawanesa decision.
all right. And is that going to be binding going forward on the LAT?
Well, Ryan's the LAT expert, so...
Well, interestingly, the LAT, there was one conference call, I understand, early on where they claimed to say that they weren't even bound by Superior Court of Justice decisions, that they weren't bound by anything. They could decide anything they wanted at any time. And someone pointed out that, in fact, the tribunals are below the courts in terms of the hierarchy of our judicial system. So I believe they now acknowledge that the Court of Appeal and Superior Court cases will be binding for adjudicators at the LAT. But the LAT itself says none of our cases create precedent, and we are not bound by FISCO precedents. So my understanding is Henderson is a FISCO decision, right, Darcy?
Yeah.
So there is an argument there that they're not bound by it, but until there's a decision to the contrary, I would continue to rely on Henderson, and to me it only makes sense. I mean, to create such a convoluted system as they have, and then to say you've got to take $20,000 of your $65,000 in benefits just to get Dr. Kaplan and his team to even put in an application, that's contrary to the spirit of the legislation.
I wanted to ask Ryan a question about the LAT. In terms of the LAT seems to provide more of a platform for insurers to initiate adjudications.
Yes.
And the question I have for you is, do you expect insurers to use that to their advantage in relation to treatment plans or CAT assessments or IRB entitlements or anything else?
I would be surprised, Darcy. It depends on the sort of case. I mean, it may be a situation where they're concerned that it's a very small case with a staged accident, and they want to get it in front of an adjudicator and have some consequences. But in larger cases with legitimate injuries, I don't know what advantage there would be for them to initiate a LAT proceeding after a denial if the insured person doesn't want to do that. Maybe I'll be pleasantly surprised, because any cost savings to the insured person, if we can, get the process moving forward, is a good thing for our clients. But I think I'd be surprised if it was used very often in legitimate cases.
Somebody asked, what do you do if your broker doesn't explain the optional coverage to you? And surprisingly, I had a conversation with my broker and said, how much is it to buy up to the previous level of coverage once the June 1st changes take place? And she told me that there were no changes. So they're completely unaware that there were even changes, let alone able to cost out what the optional coverage was going to be. Why don't I turn to you, Ryan? Do you see broker liability as an increasingly interesting area?
Absolutely. It's something we're always going to be alive to in all of these cases. I mean, we've always looked at things like IRBs. You have someone who has no private disability coverage, and they don't buy up the $1,000 a week income replacement despite the fact that they're making all kinds of money. In those cases, we have gone after brokers for failure to offer or explain the optional coverage to the client. And that's going to be even more the case going forward, particularly with increased liability issues. I mean, anyone with any sort of good job and assets should be buying at least $2 million in liability coverage to protect themselves, and as well as the optional coverage. So it's something to always look at when there is a broker. Brokers have a fiduciary duty to explain the coverage available to the insured person and to make sure they buy the appropriate coverage. So I think that's something that should always be on people's radar when you have cases where there was no optional coverage purchased, but you think that the person would have purchased it if they had been properly informed.
Right.
Yeah, no, I agree with that. I mean, the general principle is that you're not supposed to get money twice. So if the benefit limits go from up high here to down here, your lawsuits get much bigger. And if you only carry a $1 million liability policy, it's inadequate. And everyone should buy up to at least $2 million, if not much more, to protect themselves and their family for not only causing accidents, but for accessing it if you're hurt by somebody with a modest insurance policy.
Right. Are there still IMEs, one person asks, under the new system?
Are there still insurer exams?
That's essentially it, yeah.
Yeah, it's a very interesting question. Whether, because as you know, under the present system, the insurer does not have to get an insurer exam to deny a benefit. Most of the time they seem to. Sometimes they rely on out-of-date and inappropriate IEs, but presently the insurer exams are a big part of the cost of the accident benefit system, and I imagine they will continue to be. I imagine adjusters will get them for the same reasons they get them now, because they don't have the medical knowledge themselves to make a determination. One of the changes, though, that's relevant, and that's from the LAT. The LAT now has a form equivalent to the Form 53, which we have to sign when we're experts appearing in court. Presently, an insurer examiner does not have to sign a form saying that their obligation is to the trier of fact for objectivity, neutrality, and fairness. But going forward, there is a form that has to be signed. So my question is that form for anybody who's going to be speaking at a LAT hearing, or anybody who submits a report or an OCF 18? Is a treating psychologist going to have to sign the form, or is it only for the insurer examiner who is submitting a report? So we do have that form. We now have a written obligation for neutrality and objectivity, and I'll be interested in seeing if that form and the implication behind it leads to any change in the type of reports that people write, and whether it'll be something that LAT adjudicators address, just like judges sometimes address the inadequacy of us assessors in terms of our fairness and objectivity.
Right.
And just to add in, I think the issue of IEs and whether they become more popular or less popular depends on which change you're looking at. So, for example, they've essentially eliminated the non-earner benefits, and you're not going to see IEs in relation to that entitlement because it only goes for 2 years now. You'll still see them in relation to the post-104, the 2-year mark,
right,
IRB entitlement. And arguably, what used to be the $50,000 in non-cat med rehab has been technically increased to $65,000 because you don't have to spend any money on attendant care and you can use it all. So in the non-cat cases, with a shortened 5-year as opposed to 10-year window, you may see IEs more common to deny, delay, stall treatment so you don't establish a burn rate and access the $65,000 in that 5-year window. And then on the catastrophic issue, I think once the designation is achieved, insurers will probably back off and accept that the $1 million over a lifetime is going to be exhausted and not IE it to death.
A couple of people have asked, Ryan, who's going to make up the LAT? Do you have a handle on it? Is it arbitrators coming over from FISCO and it's the same old, or is it a whole new cast of characters?
I'm not 100% on that. I do know that several former FISCO people are now working at the LAT. I've heard differing numbers as to how many of them are there. I think a number of them are new hires who are coming to this from some other discipline. And so there will probably be a steep learning curve for all the adjudicators in terms of getting up to speed on the new legislation and on accident benefits in general. But I do think that there will be a core group of people who were at FSCO, hopefully, who will help educate these newbies into the world of accident benefits.
Yeah, let me just ask a question to Ryan. I'm curious as to whether we're going to be getting written opinions at all, and whether they're going to look like the written opinions from the FSCO arbitrators, which are often very comprehensive and sometimes take a year to be written because they deal with careful review of the legal precedents. What do you expect people to be writing?
Right. Well, I think that remains to be seen. I don't think there's anything in the rules of practice that sets out you have to have detailed reasons for decision, but I would expect any tribunal, I mean, especially one that's subject to judicial review, there's a requirement for written reasons to explain how they arrived at their decision. If they use boilerplate language or they don't put any reasons at all, then that would be an easy way, I believe, to go to the judicial review process. So I believe there will be written reasons that they'll be somewhat detailed. Now, if it's a treatment plan for an orthopedic mattress, it might be only a few paragraphs. If it's a post-104 IRB, I expect it would be more like a traditional FSCO arbitration decision. But that will obviously become more clear as we get further away from April 1st.
Just staying on the LAT theme for a moment, is it your plan, and is there a cost savings to gather up denials? If you get one and you think there's going to be another 4 or 5 coming, I'm going to wait and do one application and put all of the disputes on it, and is that going to cost $100, or is it $100 per dispute, even if it's only one application?
No, my understanding is that it's going to be $100 per application. So the gathering up of disputes is probably going to be the way to go. I mean, if you have big dollar items or essential items that you just need to get adjudicated, then those will be done as a one-off. But I believe our practice, at least right now, is going to be, if we've got a couple of small denials, we'll wait until we've got enough of them to warrant going to the LAT. Particularly because you're actually now, with this 6-month timeline, going to be going to adjudication very early, and that's a lot of time and a lot of energy to go through a process like that if the dollar figures at issue are small and they're not something that warrant all that process.
Right. And the thing I'm worried about when it comes to the LAT is the written procedure, and you don't have a lot of say in what kind of hearing you're going to be forced into. So if it's something like a psychologist submitting a treatment and assessment plan and it's denied, if the paperwork in support of that treatment assessment plan is not comprehensive and persuasive, the adjudicator on a written hearing may just write an unfavorable decision saying it's not warranted based on the evidence, and that could haunt the claim, lead to further denials, have impacts on the tort case. So this whole written hearing scares me considerably, as well as the fact that the LAT process is a very terrible cost recovery element. So we cannot, on behalf of claimants, recover considerable expenses we may spend or our time to any great extent, and that's going to cause some hurdles for self-represented people and for others.
Let me ask a question about our reports as health professionals then. One of the things that you read when you read the LAT material is they're going to potentially limit hearings to 2 experts, but they also talk about limiting reports to 12 pages or wanting summaries. And I'm wondering if, because we've been thinking a lot about, do we change the way we summarize the conclusions in our reports so that they stand out from the body of the supporting evidence in the report? And are we going to be really asked to change the way we summarize or write all of our treatment plans and our opinion reports about post-104, non-earner, attendant care, and CAT? And do the lawyers imagine giving health professionals advice about how to change the style of their report so they will be read by an adjudicator?
Interesting.
Well, I'll tell you a little secret, is that every lawyer looks at a report, looks at the conclusion section first.
Anyway.
Right.
That's the first thing we do. We flip to the last page, look for conclusions, we read the paragraph, we get the gist of it, and when we have time, we go back and read the rest of it. So the more that's up on the first page, the better, and with explanation to follow.
And absolutely. I mean, I always encourage healthcare people to write in clear language designed for lay people to understand and to make it have a summary section and to have their opinion front and center, because that's how people digest information and how you write persuasively. And so I think that's going to be even more important under this new system, and everyone should try to write in as few words as possible with headings and clear language. Because I think especially in today's day and age where everything is digital and people's attention span is going down and down, long narrative reports, while in certain circumstances, particularly when we're talking about these complicated GOSE tests, may be warranted, for many things, shorter and clarity are key.
I agree, and I think all three of our firms have papers about medical legal report writing to assist people that are new to it or don't feel they have the adequate skills to write a persuasive report that isn't biased, but it's simply laying out your opinion in a cohesive way that an arbitrator or an adjudicator can take, and it's almost like a ready-made decision because you've laid out your rationale for your conclusions nicely, and it's easy for them to say, well, I prefer this opinion over this opinion, and they've almost got the decision written. In an ideal world, that's what the reports would look like. I'm sorry that the questions I lose them because a new one comes and it puts it off. There's a lot of questions surrounding children that live in remote areas. And that don't necessarily have access to rehab hospitals. Ryan, why don't I turn that over to you and give us your thoughts on that and the implications for the SABS?
Well, that is going to be a factor with respect to children with brain injuries, and I'm not sure there is a ready-made solution, but one of the good things in the new SABS is that it just says that you have to be accepted for admission to one of these hospitals, not that you actually need to go. And I think if pediatricians and physicians understand the consequence of an acceptance, that it's going to go from $65,000 to $1 million for these people in remote areas, I'm hopeful that we'll be able to develop a practice of trying to get people admitted to these hospitals on a wait list. And then once they're, accepted for admittance on a wait list, and once they're accepted, then as long as they've got the imaging that's required, then they're CAT. And whether they ever go or not is not an issue. So I'm hoping that rehab people who are watching this, in conjunction with treating physicians and people who deal with admission to facilities like Bloorview and others, will hopefully come up with a strategy for getting as many people as possible into this KID-CAT definition, as Darcy calls it, and off of the public dime, because that's really what this insurance is for, and these are the people who need it the most.
I want to mention that the definition says that the hospitals will be named in a guideline. So I think it's a question is, will that guideline address the issue of fairness? Because obviously in Southern Ontario we have access to those hospitals. But if those hospitals are not available to children in the rest of the province, what should the guidelines say about that? And I think the government could address that.
Excellent. Somebody asks here, under the GOSE-CAT criterion requiring positive imaging, would a skull fracture count? There's a bunch of questions about the positive diagnostic imaging. Dr. Kaplan, what are your thoughts on that?
Well, when you look at that definition, there's a couple things to say about it. The definition is a fairly long one. It talks about specific technologies, and it talks about specific brain changes, but then it has the broader term, which is medically recognized technologies, and the broader term intracranial pathology. So the question is, I would think any damage to the brain meets the definition of intracranial pathology. It doesn't say the size and scope and nature of it, so it's a broad definition. And the medically recognized brain diagnostic technology, that's an area of change over time. We have all kinds of new technologies which are able to describe the diffuse axonal injuries, for example, that occur with the shaking of the brain. there's metabolic and physiological and neurochemical measures in the first few weeks after an accident. And so there's two questions. Are these medically recognized, or are they simply experimental new approaches? And are they accessible and available? And the problem is that even if they're medically recognized, they aren't available. They're not done in an acute hospital setting or in a trauma hospital setting. So one of the things that lawyers and health professionals have to think about with the severely brain injured patient is, are there medically recognized technologies which should be ordered, which aren't medically necessary but are necessary for documenting the case? This legislation pushes us all in the direction of ordering tests for the sake of demonstrating pathology, where demonstrating that pathology doesn't change the treatment regimen, but changes the funding available. So, and the question is, can health professionals give lawyers advice on what is medically recognized and what should be ordered? And should those costs be borne by the system? So lots of questions.
But would you say skull fracture doesn't fall into intracranial pathology?
No, the skull fracture may be associated with intracranial pathology. It often is. But is there a depressed skull fracture? You know, what is going on underneath the fractured skull? Is there tissue changes, and can you document that?
Right.
So here's where we need to work very closely with the radiologists and other experts in the hospital settings when the patient is being evaluated. What technologies do you have that you can use in this case?
Somebody asks, will there continue to be a role for a case manager? Asked by a nervous case manager, I suspect. Thoughts on that, Darcy?
Case managers we strongly support them. The work they do in coordinating is invaluable, and we encourage it, we recommend it, we welcome it, we love it. It takes a lot of responsibility off our plate when you have a competent case manager. The problem we face is that the CAT designations are going to be delayed. And without a cooperative insurer, we're going to have to find ways around that to get the case managers involved, at least on some kind of basis, to monitor, to help, to assist, protected bases when there's a tort claim and the rest of it. But frankly, the roles of a case manager in the first few months post-accident are going to be substantially reduced, except in the most obvious quadriplegia type cases, or the children case where there's a widening and more access than ever.
The only possible option, and I've had this in other cases that are non-catastrophic, where you have an experienced adjuster who recognizes that at the 2-year mark there's going to be an application, and that there's all kinds of different treatment providers involved who are maybe running off in different directions, and they say, I'm going to give you a budget of $5,000 to have a case manager come in and to try to get everything moving in the proper direction and have rehab goals and coordinate the care. I'm hopeful that there'll still be some opportunity to do that in cases with serious injuries where it's likely at 1 year or 2 years that there are going to be CAT applications, but it will all depend on the insurance adjuster, because it's not something that they have to pay for absent a determination of catastrophic impairment.
Likewise, somebody asks, will there still be a need for life care planners and future cost of care reports in non-CAT cases?
So I'll start more than ever, more than ever, with reduced limits and the inability to access the CAT designation automatically and right away. Then we're going to rush tort cases, meaning issuing tort lawsuits within a few months of an accident or weeks rather than waiting close to the 2-year mark. We cannot wait. We need to access funding. Go, go, go. And a key element in the tort cases are the future care cost reports. So we're going to get those at the 1-year mark. They're going to be more popular than ever, right?
As long as there's a tort claim, obviously.
Right.
If it's non-CAT and there's no possibility of suing anyone, then there will be no need for life care plans. But I think the number of cases that we have under the current system where we're getting life care plans without a tort component is not a huge part of the work that life care planners are doing.
A question for Dr. Kaplan. Will neuropsychological assessments be used as evidence of brain injury and taken as criteria towards the CAT status?
Yeah, I'm working with other neuropsychologists right now to review that literature to look at the whole issue of sensitivity and specificity of neuropsychological testing for determining intracranial pathology. Previous reviews of the literature have said that it is sensitive. So the question is, is neuropsychological testing the type of medical diagnostic testing you want to present to a lab adjudicator and explaining it and explaining that it's equivalently sensitive to other things, etc. So I certainly think by pulling that literature together and understanding it and presenting it in selective cases, that's certainly something that should be done.
But it is contentious.
Very contentious, because even though this definition is broader than it could have been, what is the specificity? For example, if you're seeing an image on a CT scan, is that likely not to be intracranial pathology? While with neuropsych testing, what other things could you be measuring besides intracranial pathology? So, but it certainly should be part of the presentation of the patient. Yeah.
Somebody asks, will hemosiderin deposits qualify?
That's very interesting. I think that has to be presented to an adjudicator, explaining what they represent. You know, that they represent damage to the central nervous system with behavioral implications. Yeah. So we're really going to need our medical experts on those kinds of things to explain it very succinctly in their reports. You know.
I don't know if it's 10:30. I don't know if we have time for one more question, but I guess we'll keep talking until somebody tells us we're finished. There's a lot of questions about protected accounts. People want to know if there are any changes to the timing of settlements, protected account on the AB side, because the comment was health practitioners need to be paid, and there's only so many of these protected accounts that they can take on. So they're wondering, what will the timing of settlements be, and will they be able to collect interest on their protected accounts? Maybe I'll turn that over to you first, Ryan.
Well, in terms of the timing, I think it remains to be seen. I believe that the accident benefits claims are going to take, for the serious cases, are going to take just as long as the current ones do to resolve. And in many cases, we can't settle the accident benefits before the tort claim due to issues with collateral benefit deductions. The interest issue is something that is open for negotiation. I think it's something that there's no particular rule about how that will work. So it'll be something between the law firm and the patient and the provider with respect to interest. Obviously, as Darcy mentioned earlier, we're going to try to move these tort cases along just as quickly as we can, because these poor people are going to be totally at sea without the current accident benefit system backing them up. So that's the only positive I can say with respect to protected accounts is we'll all try within the confines of the justice system, which is a slow beast, to move these things along quickly and get them settled as quickly as possible, because that's to the benefit of our clients, and it will have hopefully the concurrent effect of people being paid earlier rather than later.
And I would add that if the protected account is on the basis of a probable CAT designation, then when the CAT designation is rendered, the invoices ought to be paid by the insurer with the 1% compounded monthly interest, subject to the, when you're in a dispute, the interest rate goes down, provisions for the LAT now. So there's an argument for interest. If it's a tort-protected basis, it's unlikely that a substantial amount will be allocated to interest, and it is a problem, and we're aware of it, and we'd like to try to find some solutions.
And thank you. With that, that is our time. I've got a note here to wrap it up. Just in closing, I'd like to remind people to get their bursary applications in. May 31st is the deadline. That's the educational bursary for community healthcare workers. PIA Law is pleased to present. A lot of P's in that. And just a reminder that our next PIA conference is the Back to School Conference. It's Friday, September the 16th in Toronto. By then we may have some cases, some more information, and obviously this will be an evolving beast over the coming weeks and months and years, and we will do our best to keep everybody updated on that. So on behalf of the PIA law firms and Dr. Kaplan, I want to thank you very much for tuning in today. And again, you can go ahead and post your questions. They all will get answered. We were only able to touch on a fraction of them today, but thank you very much for your interest and your questions.